Hi students. Another topic in topic 4 is alternative dispute resolution. These are often used predominantly in civil matters, for matters not going to court and being settled out of court. Can be done for criminal matters, in particular when there's plea bargaining between the prosecutor or the DPP and a defence lawyer. These are the options we often use rather than go to a tribunal or court. They're obviously quicker, more efficient, and they also are far less stressful. There are many different methods available, and unlike court outcomes which have a legal consequence which can be enforced, ADR is also not overly used to be enforceable, but more of an agreement between two parties. There are two main types of ADR. The first is direct party control, and that is where the party themselves try and resolve the dispute. So if you're having a disagreement with your neighbour over noisy music because you're trying to get to sleep because you've got to go to work, you might go next door, and that would be called self-help, and ask them to turn the music down and explain that you're trying to sleep. You may put in earplugs, abandon that there's any concern, and let them play their music and have no conversation. You might concede that they're just who they are and music's part of your life, so you're going to leave it. Or you might come to a consensus with them that you're not, against music being played, but maybe to a certain hour or to a certain level or on a certain night when you're not working. So they're your options available to you. Each of them have dangers though, because they can escalate the matter or make it more hostile. Sometimes matters are really fractured and it might require mediation, such as a divorce or separation between two people. Conciliation is similar to mediation with a little bit more force and again some direction. And arbitration is where there is an arbitrator who can force decisions upon you like a tribunal. Mostly these disputes are used for family matters and neighbourhood disputes, but again that some estimate over 90% of all civil law is settled out of court, and it would be very, very rare for the police not to use ADR in plea bargaining over a range of offences. ADR is a common question in the exams, but it is again somewhere a lot of time lawyers are spending time getting parties together to get resolution rather than going to court, because court costs and lawyer costs from the courts can often eat into any compensation or settlement. That was a past exam question from a few years ago. You would normally discuss 3 examples, whether they are direct or indirect, and you would discuss or define what it is, explain how it works, and what's a positive and what's a negative to gain the full marks. Thank you.